Good afternoon, ladies and gentlemen. It's a great pleasure to be with you this afternoon to share some thoughts about succession. The earlier morning discussions were wealth and how does technology help to maximize returns on wealth and the avenues for wealth. The focus of my discussion would be, where does this wealth come from? So in the Indian scenario, if you were to look at any individual, who, be it ultra-high or a high net worth individuals, there are various sources from which wealth comes in. It comes in from a way of life. So basically, wealth in Indians, when they hold it, is essentially in the form of ancestral wealth, which might have been inherited from forefathers. It could be agricultural land, non-agricultural land, buildings, bungalows, huge flats. Or in the Indian system of life, it could belong to a Hindu undivided family. These are nebulous concepts because these are not today engrafted in any law, except where succession is concerned. So when one looks at the source of funds which have to be invested, financial advisors should know in whose name should that investment be made. You have the concept of beneficial ownership and you have the concept of legal ownership. A question which was well recognized in the law for many, many years, but the Companies Amendment Bill 2016 makes a clear distinction between what is beneficial ownership and what is legal ownership, and that has been given, which has been acknowledged or has to be acknowledged by companies while recording ownership. In addition to this beneficial ownership, you have laws that are peculiar to certain families. For example, certain religions allow you to have more than one wife. And the question that arises is that if a person has left behind wealth, which the wives collectively collect, which is the taxable entity where the wives are concerned, should a financial advisor break up that investment into different names, or would the conglomerate of these individuals constitute a different taxable entity? These matters have gone to court, and they said that these wives who have not actively involved in doing business or making investments would be collectively taxed as a body of individuals. So you have sources of income which goes down from generation to generation, either because of a family you're born in or because of your own personal laws which are applicable to you, or you have inherited wealth, and also leaves you the option of making wealth yourself. For example, you might be a doctor, and a financial advisor might go to a doctor and say, would you like to make an investment? Now, the doctor doesn't know whether he is practicing medicine in his own name or he is practicing it on behalf of his family. He is entitled to do both. It's quite common for doctors to have two clinics, one in the morning at one location, second in the evening at another location. And can one individual say that in the morning it's my individual practice and it's my individual income, and what I learn in the evening belongs to my family because that's my family income? The answer is yes, it's absolutely possible to do that. Now, this is an idea which a financial planner may cede to a professional. Is it confined only to the medical profession? Of course not. You can do that with any other professional. You have different capacities in which you can practice your profession, and the income would then be attributable to that particular entity for whom you are carrying on that profession. As a result of carrying on your own business, let's say you are a software engineer or you are a medical professional, you might be able to develop a patent, a trademark, a copyright. Or if you are an artist, you might be entitled to royalty income. The question which arises is, where should this royalty be collected? And if you are a wealth advisor, it might be good to get into a frank discussion and say that I want to treaty shop on this. Do I have an option of validly minimizing my tax liability? And seeing that this income which I get, even after I stop singing or performing, continues to me as royalty in a tax haven, which then opens up many vistas for the purposes of investment. You then have disputed liabilities, disputed claims, which might have been an inheritance which you got when you inherited property. I need not dwell upon that at great length now. I'll go to the last aspect of what is the nature of wealth, and that's contractual. Many of us are aware that insurance policies are often looked upon as a tool of tax planning for the purposes of deferring income. In the past, actors and managing directors of companies used to get insurance policies where the beneficiary was the company or the entity, and after a few years would have the policy endorsed to the individual so that on retirement, you received a lump sum amount from the insurance company. For short-lived individuals, short professional life-lived individuals, these are great tools of tax planning. They are great tools of revenue, and they are great tools of security of income in your graying years when professional income might cease. Could you get more than one insurance policy? The answer is of course. There is no limitation to the number of policies that you can get, though there are certain types of investments which limit you to only one type of a policy or one type of an investment. That takes me on to how does one really create wealth, knowing from which sources it comes. If you were to start a business, for example, your basic investment will come from savings. So if you take up a job, or the day you're getting married, or the day you were born, these are all great occasions in life to ensure that you get a tidy sum by way of tax-free income. After that, you start looking at available tax tools for the purposes of retaining that income or maximizing after-tax revenue. A simple example which all of us follow is that we take a housing loan, and whether we are liquid or not, prefer to pay interest on the housing loan because you are allowed a rebate on the tax and can make use of your savings for alternative investments, which might probably yield you a return higher than the interest you pay on your housing loan. You could then have windfall gains. This often happens in case of contracts where you might have an escalation clause. And if the government or under any PPP agreement, you are entitled to an additional claim, you would be entitled to that claim after you have ceased business, in which case the person advising you, or all of you who advise individuals, will have to ensure that the entity which is entitled to the windfall gain continues to be in existence, continues to do business. Otherwise, because of a technicality, you would be losing your right to receive this additional compensation. We then come to retiral benefits. The scope of retiral benefits is increasing tremendously. As a result of the LRS scheme, which has been announced by the Reserve Bank of India, which had curtailed the amount of investments that can be sent abroad and has now been liberalized, there is a whole avenue of international investment that is possible. There used to be restrictions on having foreign homes. That has now been removed. The amount that an individual can remit abroad is on a year-to-year basis, irrespective of the age of retirement or retiral. If one were therefore to plan and say have families abroad and look for avenues to be able to sustain a family abroad, you might decide to stay in India. Your retiral benefits might be enough to pay you keep your standard of life which you have been enjoying in India, and during your professional lifetime, remit monies abroad to be able to set up your kin abroad in any country that you may like. In addition to that, you may decide to also look after your investments and ensure that after you, where succession is concerned, you are sure that the next person you would like to, the next person to receive that income is a person of your choice. So normally on a share certificate, you would have that person as a second name. In a conveyance, you would have that as a second name. or in any other savings account, you would have that as a second name. There was a controversy when the Companies Amendment Bill came in, whether this second name amounts to a beneficial ownership in the asset that devolves on that individual, or whether that individual only holds that in trust for the legal heirs, whether a disposition is made by will or it is an intestate death. The position is now fairly clear that a nomination or a second name does not entitle ownership of property. You only hold that in trust for the next of kin to be able to receive it. In this planning which takes place, we have professions like the medical profession, the architect's profession, the legal profession, as we see today, and sad to say, even as individual directors or independent directors, where you might be fastened with a liability for probably no fault of yours at a late stage in life. You may therefore like to have an asset protection trust, where you might be wanting to vest all your assets, where you are able to exercise control over those assets, but God forbid, if you are ever called in for the purposes of claims, those assets stand protected. You would then want to ensure that during your lifetime you enjoy the income of those assets, decide at what periodical intervals you would like to receive that income, and after you are no longer alive, you want to pass them on to the persons you choose. Need not necessarily be family, need not necessarily be trusts which are created in India. You could, even with respect to Indian assets, have foreign beneficiaries who can receive that income. So when we are looking at the wealth which you own and the wealth which you want to distribute after you are not there, you do that through a medium of trusts, ensuring that you are able to keep the income of that trust for your lifetime. The only important point to be kept in mind while doing this is that though you might be enjoying the usufruct of an asset or the income of an asset during your lifetime, there are certain limitations in geographies and in personal laws which do not allow you to bequeath the entire amount of that wealth to whomever you like. So we need to ensure that you have taken protection to see that the asset which you are passing on is not constrained in receipt as legacy because of the geography or the religion to which you belong. In order to therefore ensure that after you have enjoyed the property, you are able to pass it on to people you want to receive them, you might want to keep all what you do extremely confidential. You might want to see during your lifetime that the devolution has taken place in a manner that you want it to happen after your death. So you have a toss-up between whether you should create a trust and a will. When we are talking of high net worth individuals, we are not talking about administrative costs of whether one should be looking at a trust or whether one should be looking at a will. That's taken care of. The best, of course, is to have a combination of both, and trust as well as a will. Where a trust is concerned, it is the passage of property where legal ownership vests in the trustees with an obligation, where the persons who hold that property are not entitled to the use of that property except to direct the income and the distribution of that wealth in a manner that is decided by the settlor, as it's called. There are several safeguards which one takes when a trust is concerned, because some nasty experiences have shown that once wealth goes into the hands of trustees, though it is your own wealth, they can act very difficult where distribution is concerned, though what you make is a legitimate request. In order to ensure that these things do not happen, you have the protection of a protector or a letter of wishes, which are matters of guidance for which the trustees have to follow. But very often, one feels that I get a big exemption in stamp duty if I were to do it by a will. Go ahead and do it by a will. But as you know, recent disputes in Indian courts have shown that in the best of families and in the highest of families, wills have been contested. So in order to ensure that there is no contest, it's best to have a combination of these two, depending upon the nature of your family, the religion you belong to, the spread of your assets, and the ultimate beneficiaries to whom you want the income to go. In deciding who the recipients of this income should be, the aspect of an investor's existence, if I may use that expression, is torn between various demands in his personal life. He may want to do philanthropy. Almost every Indian wants to visit his hometown, wants to go to his Guru Devta's place for a pilgrimage, wants to do something for a village. These are objects which can be served through mediums of trust, in spite of the fact that the tax laws are getting more and more severe where their application is concerned. You might be confronted with situations where you have special children, where you have a girl child, a divorce, a division of assets where you want some of your family members to ensure the same style of life which one is accustomed to, in spite of the personal tragedy that might have fallen on a particular individual. These are occasions where succession and the nature of investment to be made becomes of utmost importance. For example, if you were to have a building under construction and then you were to have that building transferred to a limited company and say that I'm willing away the shares of that company to an individual, the poor legatee would not even understand the complexity of that structure and come to a question of how do I value the shares of this company if I want to make a sale when the construction is complete or not complete. Simple questions which we ask ourselves. So these are issues where financial advisors are so proximate to their clients that the choice of investments should be made known to them with options. REITs, for example, is a matter which has been debated by the government for a long time, and we are expecting the law on taxation to get more liberal and more clear as time goes on, where people are able to enjoy benefits of REITs. And it would be a community of financial advisors who could petition the government to make that liberal, because that is going to be a driving force in times to come. Legislation is also catching up very fast. For example, prenuptial agreements today to a certain extent are respected by Indian courts. Live-in relationships, particularly if it's a consummated relationship, gives your partner the right of a spouse. Your residential status and domicile, one must know, are two different facts, one which governs your foreign exchange law and the income tax law, and one which governs your wills and the devolution that takes place, which leads to the question of whether you are an NRI or you're not an NRI. It is because of these that countries like the United States have come across with legislations like FATCA, where there has to be a declaration which has to be made of assets or income which a US resident or a green card holder or a passport holder has to declare to its authorities. There is pain to the payer if this declaration is not made to them. As a result of the Panama disclosures and what we have been reading about names in the newspapers, trusts seem to have been under a cloud. But it is to my personal knowledge that some of the families' names that have come out in the open seems to suggest that what I have done is absolutely legal. So what's the question of putting my name in the press? And that's what happens to certain special locations where special islands today have been known to keep in pace with times, to be able to modulate their laws, to be able to implement trust to meet individual needs. At the same time, you have assets like insurance policies and unlisted securities, which today are used as mediums of investments for the purposes of holding wealth. Of course, if you are holding shares in an unlisted company, the question of transmitting it on becomes more difficult. So the question ultimately arises is, whom does one turn to be able to get an answer to all this? And it is you, because you are the investor's friend, one who provides love, advice, and coffee. You are a treasure to your clients. Thank you.